Hello everyone. Today's webinar is on informal discovery. What is informal discovery? Formal discovery is a request and disclosure of evidence between parties of a lawsuit. Informal discovery is a voluntary exchange between parties. That is what we are doing, involuntary exchange of information. What can you expect from us? We will provide the following to members: an EIR letter, which is also an error resolution and information request, a letter of rescission, and a letter of dispute will be sent when we receive your notice of default in a timely manner. There is a 30-day window in which to dispute your notice of default. Do not send us a notice of default and expect us to do a letter of dispute if the notice of default is a year late or 6 months late. You have only 30 days in which to respond to this notice of default and dispute that debt. When we dispute that debt, we want to make sure it's done correctly. Now let's ask, what is an error resolution and information request? Well, a notice of error is any written notice from the consumer that asserts and includes specific errors. Now, once the servicer has received a notice of error or an informal request, they have 5 days to acknowledge and 30 days to investigate, correct, or otherwise respond. What is the letter of rescission? Well, the letter of rescission is the act of rescinding your loan. Pursuant to 15 U.S.C. Section 1635, and as confirmed by the opinion of the United States Supreme Court in Janowski v. Countrywide, case number 13-684, your loan is rescinded under operation of law and therefore void. What is the letter of dispute? The letter of dispute will tell the collector the following information: that the homeowner is disputing the debt and that they request that the debt collector validate the debt. Now, many times you ask, Joe, what documents are needed for informal discovery as well as a chain of title analysis? Here is a list of documents that we will need. You may or may not have all of the documents. Please understand that the more documents that we have, the better we are at accomplishing our job and providing you with the correct documentation. So let's start with the top. A promissory note, a mortgage or deed of trust. This is the security instrument that is recorded into public recorder's office. Notice of default and/or foreclosure complaint with all exhibits. Depending on what state you're in, you may or may not have a publicly recorded default. If you are in a judicial state, you will have a foreclosure complaint with all of the exhibits. Next, we will need any assignments of mortgage or assignments of deeds of trust. Now, for members that are in the state of Georgia, you will have a security deed as a security instrument recorded into public record, and you will have assignments of the security deed. Next, we have substitution of trustee. Again, depending whether you're in a judicial state or a non-judicial state, you may or may not have this document. If you're in a non-judicial state, you will have this document. If you're in a judicial state, you will not have this document. Next, we have notice of sale. Again, this is a very important document. If you do not have this document, when we get further into doing actual lit support, we may not be able to help you until we get these documents. Next, we need any publicly recorded documents that have been filed into public record pertaining to your property that is not on this list. We need anything that has been filed into public record that pertains to your loan, not including documents filed by you. Again, let me reiterate, because many of you out there record multiple documents such as reconveyance, many different documents. I'm looking at documents that are recorded by others other than yourself into public record pertaining to your property.